Welcome to Mayor Brown's Tech Talks podcast. Each podcast is designed to provide insights on legal issues relating to technology transactions and keep you up to date on the latest trends in data, digital, outsourcing, and software by drawing on the perspectives of practitioners who have executed technology transactions around the world. You can subscribe to this series on all major podcasting platforms. We hope you enjoy the program.
In this episode, we're going to focus on the new rules for online platforms and search engines offering services to businesses in the European Union and the United Kingdom. My name is Julian Dibbell, and I'm your host. I am a senior associate in Mayor Brown's Chicago office with a practice focusing on technology transactions. Joining me today in the virtual studio are my colleagues Anna Bruder and Ondrej Hajda. Anna is an associate in Mayor Brown's intellectual property practice in our Frankfurt office. Ondrej, also an associate, joins us from Mayor Brown's London office. Ondrej, Anna, hi, good morning, welcome.
Hello. Good morning. Very happy to join you today.
Well, let's jump in here. So the Platform to Business Regulation, also known as the P2B Regulation, became directly applicable in member states of the European Union and as a result of the Brexit transition period in the United Kingdom on July 12th of 2020. So this is happening. What is it about? What does the P2B regulation try to do and how does it do it?
Well, the P2B regulation is about platform to business trading practices. Platforms are both providers of online intermediation services, such as e-commerce marketplaces, and search engines. And businesses are users of these platforms that offer or advertise goods or services to consumers in the European Union or the United Kingdom. The aim of the P2B regulation is to increase fairness and transparency in the relationship between platforms and business users. The P2B regulation is a policy of the European Single Digital Market, which is an initiative of the European Commission. According to the European Single Digital Market, platforms offer unparalleled efficiencies in access to cross-border markets and are crucial for millions of successful firms. While the efficiencies in access to cross-border markets enables them to organize millions of users, it also opens the gateway possibility of unilateral trading practices that are harmful and against which no effective redress is available for businesses using these platforms. Platforms are now obliged to refrain from certain practices deemed to be unfair and to implement an internal complaints handling system. The effect of the P2B regulation is that non-compliant terms and conditions are deemed null and void. The P2B regulation leaves space open for the EU member states to legislate for additional sanctions for infringement of the P2B regulation.
Okay, so that's a pretty sweeping piece of legislation. Who exactly does the P2B regulation apply to?
The P2B regulation applies to online intermediation services and search engines anywhere in the world that provide services to business users, and this includes private individuals who are acting in a commercial or professional capacity, who are located in the EU or the UK, to enable them to reach consumers in the EU or the UK. Like some other EU regulations, for example, the GDPR, the P2B regulation has extraterritorial application. It means that it does not matter where the provider of the online intermediation service or search engine is established, as long as it facilitates transactions between EU or UK businesses and EU or UK consumers. So, for example, an online platform that is based in the States but allows EU businesses to reach EU consumers through, say, advertising, would be in scope of the P2B regulation, and the provider of the service would have to comply with the P2B regulations requirements.
Okay. So what about this concept of online intermediation services? What what exactly does that mean? What types of online intermediation services does the P2B regulation apply to?
There are different types of online intermediation services that are covered by this regulation. There are online platforms which have a contractual relationship with a business user and which enable this business user to offer its goods or services to consumers. And that can be either by directly listing of goods or services online or simply by advertising these products. Let me give you a few common examples. We can think of e-commerce marketplaces, hotel and travel bookings websites, price comparison websites, app stores, even social media services on which businesses can offer or advertise their goods or services to consumers.
So a broad range of services, and and then put that together with the extraterritorial effect that Ondrej talked about. It sounds like we're aiming at a very large number of online platforms here.
Yes, you're absolutely right. However, we need to mention a caveat here. The P2B regulation does not apply to the following. Pure business-to-business online intermediation services, which are not offered to consumers, are not under the scope of the regulation. Also, peer-to-peer online intermediation services without the presence of business users. Online advertising tools, which are not provided with the aim of facilitating the initiation of direct transactions and which do not involve a contractual relationship with consumers, and online payment services. All of these do not fall under the regulation.
Okay, so broad but fairly well-defined scope here. If you are a provider of online services and you fall within this definition, this scope, what does the P2B regulation require you to do?
Well, there are really three topics we need to cover here. The first one is looking at the terms and conditions that the online intermediation services have with the business users. The second one is about reasons for restricting, suspending, or terminating their services to business users. And finally, it's regarding internal complaints handling systems at these online intermediation services. So I will dive into the first point, which is that providers of online intermediation services should review and amend their terms and conditions, if that's applicable, with their business users. Some of the obligations that needs to be in the terms and conditions is that the providers must ensure that the conditions with businesses are drafted in a plain and intelligible language, which means they are easily understandable and also easily available to business users at all stages in the commercial relationship. And the important points to note here is it's not only, at the point where you are signing the contract, but this information needs to be available to the businesses also in all the pre-contractual stages when you are doing negotiations. Another point to mention is that the terms and conditions with businesses need to set out grounds for decisions to suspend or terminate or impose any kind of restriction upon the provision of the services to business users. Also, they need to set out conditions under which the business users can terminate the contractual relationship and include general information regarding the effect of the terms and conditions on the ownership and control of intellectual property rights of the business users. And also finally, the terms and conditions need to include a description of the technical and contractual access of the business users to any personal and non-personal data that the online intermediation service might be able to use and access, and which are generated through the provisions of those services. If the online intermediation service is also doing some kind of a ranking or setting out any types of businesses on their website, it also needs to set out the main parameters determining the ranking and the reasons for the relative importance of those main parameters. So here think about, for example, an online marketplace and how the online marketplace is ranking the search results of the different products on it. Also, in this category, it is important that the terms and conditions set out any differentiated treatments which the providers of the online intermediation services give or might give in relation to the goods or services offered to the consumers by either the provider itself or any business users which the provider controls.
Okay, so all of these elements of the terms and conditions need to be transparent, clear, and understandable. But what if the online platform then subsequently wants to change their terms and conditions?
You're absolutely spot on here. They need to be clear and understandable. And if the platform wants to change their terms and conditions, there needs to be sufficient notice given to the business users before any changes are implemented. The regulation itself says that at least 15 days notice needs to be given to the business users, or a longer notice period when this is necessary to allow business users to make technical or commercial adaptations to comply with the changes. So for any changes that would actually require the business users to implement specific, technical standard or something like that, 15 days notice will not be sufficient, and they might need to think about a much longer notice there. Providers of online intermediation services should also not impose any retroactive changes to the terms and conditions, except when those changes would be in respect to a legal or regulatory obligation, or when those changes would be actually beneficial to the business user.
Right. So you just mentioned, Ondrej, that providers of online intermediation services should provide reasons for restricting, suspending, or terminating the online intermediation services. And that brings us to the second issue that we need to cover to answer the question what these providers need to do to comply with the new regulation. And that is, if a provider indeed decides to terminate a relationship with a business user, it should provide this business user with a statement of reasons for this decision. And the statement of reasons needs to be provided 30 days before the termination takes effect. There are a few limited exceptions to this rule in Article 4.4 of the P2B regulation, but they are indeed very limited. So as a general rule, you need to take away that you cannot simply terminate a business relationship without giving any reasons or a deadline for the termination to come into effect.
Thank you, Anna. Finally, providers of online intermediation services have to implement an internal system for handling complaints of business users. And this system needs to be easily accessible. Importantly, it needs to be free of charge, and it needs to ensure handling of the complaint within a reasonable time frame. The internal complaint handling system must comply with the requirements set out in Article 11 of the P2B regulation. Providers of online intermediation services also have to identify in their terms and conditions 2 or more mediators who meet the criteria in Article 12 of the regulation, with which they are willing to engage to attempt to reach an agreement with the business users on any settlement out of court or any disputes with the business user.
Okay, so does the requirement to have an internal system for handling complaints apply to all businesses?
No, it actually doesn't. And here the European Commission in the regulation tried to make space for smaller startups and smaller companies. So the requirement to have an internal complaint handling system and to identify the 2 or more mediators does not apply to small enterprises providing online intermediation services. And this in the EU language means enterprises with fewer than 50 members of staff and those that make less than 10 million euros in turnover.
Okay. Ondrej, I think you mentioned that the regulation makes some distinction between online intermediation services in general and search engines in particular. Do the regulations apply equally to both categories of providers? What does it provide? What does it require providers of search engines to do more specifically?
Yeah, the regulation does not treat both categories of platforms equally. And indeed, there are other sets of rules that apply to search engines. So there are two main aspects here. The first one regards the ranking of search results. And the second one regards the treatment of goods and services that are offered by companies that are controlled, that are in the same group of the search engine, of the company that is behind, that is operating the search engine. So let's talk about the first one, the rankings. Providers of search engines have to set out the main parameters which individually or collectively are most significant in determining the ranking of the results of a search, together with the relative importance of such parameters. This information needs to be provided in an easily and publicly available manner. It needs to be drafted in plain and intelligible language, and it needs to be kept up to date. This is all to to try to achieve a transparency and fairness regarding the rankings of search results. Where a provider of an online search engine alters the ranking order in a specific case or even delists a particular website following a third-party notification of any sort, the provider shall offer the possibility for the website user that is concerned to inspect the contents of this notification. And now jumping into the second aspect here, the second issue, providers of search engines need to provide a description of how they treat and rank goods or services that are offered by themselves or by website users that they control. And in particular, how this treatment is different to the treatment that is offered to other website users. This description should refer to the main economic, commercial, or legal considerations for any such differentiated treatment.
All right. So is that sums up the effects of the P2B regulation on the targeted providers? I guess just one last question, sort of the question on everybody's mind whenever we talk about EU regulations. What is the effect of Brexit on the P2B regulation? Will it apply to UK businesses?
So right now, as we are recording, the UK is in the Brexit transition period, which means that any EU regulation that are come into effect during the transition period will also be applicable to the UK. The P2B regulation, also known in the UK as the Online Intermediation Services Regulation or OIS regulation, is directly applicable in the UK as of 12th of July when the regulation came into effect. And the UK government has also announced that it will stay a part of the UK law at the end of the Brexit transition period. At the end of July, the UK government published a statutory instrument amending the P2B regulation with respect to the UK at the end of Brexit transition period. And what the statutory instrument did is basically it removed references to the EU and EU institution throughout the regulation and replaced it with references to the UK and UK versions of it. However, the rules and requirements applying to providers of online intermediation services and search engines in the UK will remain substantially the same as before the end of the Brexit transition period. So to sum up, there will not really be any changes to online intermediation services and search engines who need to comply with the regulation right now at the end of the Brexit transition period. They will have to continue to comply with this regulation.
Oh, great. Well, thank you, Anna and Ondrej, for that very informative summary. Listeners, if you'd like to know more, the European Commission has also published a questions and answers document to help providers of online intermediation services and search engines comply with the P2B regulation. We have included a link to that Q&A document in the podcast description. If you have any questions that you'd like to ask us directly about the P2B regulation or anything else related to technology, transactions, and the law, please email us at techtransactions@mayorbrown.com.
We hope you enjoyed this program. You can subscribe on all major podcasting platforms. To learn about other Mayor Brown audio programming, visit mayorbrown.com/podcasts. Thanks for listening.